pieces of apparatus. They were here less than 10 minutes, and Glendora videotaped all the excitement. You'll see it on TV. No torts since number 375 Sunday. 1:30 p.m. Do the Wall lawsuit for Friday, number 31, What Happened? Insert, Candy Alpucci's sister blew her horn twice on November the 5th, 93, Friday at 7:20 a.m. Nella Alpucci blew her horn once the same day, 1 minute later. Glendora fasted for 2 days. It is nice to exercise the discipline. No letters have been returned this week. The count of harassments and law breakings so far is 378 since April 1993. 2:30 p.m. Check the CPLR for service upon an infant. In this lawsuit, 3 infants are being sued. That would be Kevin Larkin, James Walsh, and Theo Alpucci. And you have to serve them differently than you serve an adult. 2:45 p.m. Write the wherefore. 3:35 p.m. It is done. Glendora has finished writing the lawsuit. She started it October 4th. Here it is, November 7th, 6th actually. That is 1 month. And it's 142 pages. Hooray, it is done. 3:48 p.m. The work on making the master copy of the lawsuit has 512 counts, 8 causes of action. 3:59 p.m. The first 40 pages are ready. The time on wall today is 3¼ hours. David has a key job at IBM. It's his job to lock it up at night. On November the 7th, 1993, Sunday Communion, Franklin made the master copy of the lawsuit, 144 pages, and took it to have 3 copies made. Glendora talked to Mark Davies after church, and Mark Davies ran for Supreme Court Justice, and he got 180,000 votes. That's good. Now maybe next time he'll win. He got his name before the public. If he had won, he might be deciding this Wall lawsuit case. Evans Brewster is a member of our church. He's also a judge. Yesterday, sad to report, there were 3 laws broken. The man in 2D, taking his cue from the Walsh family and the Alpucci family, blew his horn twice under Glendora's window at 4:45 p.m. Then he got out of his car, walked toward his own building D, and looking at his own living room, shook his finger. Then he cut across the lawn, eventually killing the grass, which is bad. He should use the walks. 6:20 p.m. Theo Alpucci went by Glendora's window, making loud whistling sounds. And you remember the ordinance? Shouting, hooting, whistling, etc. at any time of the day or at any place so as to annoy or disturb a person's peace, quiet, comfort, repose. Remember that? So that was and then at 7:07 p.m. there was voice harassment, and the time on wall this week is 34¼ hours. The money spent is $182. 1:20 p.m. do the envelopes for this week's mailing. Videotape the What Happened this week for TV. And the secretary says, I know this job so well. I can do it backwards. And the boss says, and she usually does. Here is the CPLR, Civil Practice Laws and Rules for New York State. Section 309, personal service upon an infant or incompetent. Upon an infant, personal service upon an infant shall be made by personally serving the summons within the state upon a parent or any guardian or any person having legal custody, or if the, well, we won't get into that, if the infant is married. These infants are not married. But if the infant is of the age of 14 years or over, that would be Theo Alpucci, the summons shall also be personally served upon him within the state. Does that mean you have to serve it to the parent and to him? I guess so. That's what it means. And here is the lawsuit. Now, I will, it's going to be served tomorrow, November the 8th, 1993, Monday. And then I certainly won't read it all to you because you've read it all. You know everything that's in here practically, but I will read you the causes of action. I will read you the wherefore. The rest of it you all know, because it consists of the logs that you've heard every week. And I'll read you the summons with notice.
Patrick and James Walt's sister were around here yesterday when we came home from church, and they were playing with shaving cream. Then we went out to do some errands, and also I called on a prospective client. And when we came back, there was an egg broken and strewn all about the threshold of our apartment door. Also, on the kitchen windowsill was an egg broken and dripping down the side of the building, the outside of the building. On the southwest window, there's a whole bunch of shaving cream. We had piles and piles of trick-or-treat candy to give the children. Nobody came except these demons. Now, at around 10:30 at night, there were 6 very large Negro boys in their upper teens, and they were all around the building, and I don't know if they're the ones who did the shaving cream or not, but it wasn't trick-or-treat, it wasn't fair play, because they never came and asked for the treat before they did the vandalism. I'm all opposed to this Halloween thing anyway. I like giving kids candy, but Halloween is All Saints Eve, and it's supposed to be a holy day, not a devil's day. About the egg in the front hall, it's just going to sit there until it turns rotten and full of sulfuric acid, so that Roberta Walsh and James Walsh, who are the prime suspects, and Daniel Walsh, get tired of smelling the rotten egg. Darlene tells me she's going to stay another month. I gave her a piece of my home-baked bread with butter on it to do to you until we find out you're in, and then get over there. About that matter, you understand that I do have a lease signed by you and by me for 2 years at 988, I think it is. And actually, I don't really have to do anything. But because you're a good landlord, and because I like you, I will listen to what you want to do. Okay, now today's joke. Did you hear about the inventor who crossed a TV set with a microwave oven, and now he can watch 60 Minutes in a quarter of an hour? Take care. Now, how much is this my new detective? Oh, yeah. His name is Lieutenant Quinn. Lieutenant Quinn? Oh, very good. Yeah. Lieutenant, huh? Yes, and he... and he came... Yeah, that's pretty good. And he came up to see me already. Very good. On Friday. Okay, did you tell him any jokes? I can't remember if I did. And we have a meeting with each other on Wednesday at 2 p.m. He's coming up again. Good. And so I wanted to tell you that. All right, I'm glad. I'm happy for you. Good. He's a nice man. He is he seemed to be very nice. Yeah. And so I'm going to talk to him again. His extension is 6111. Oh, no. Yeah, 61111. Do you want to connect me, or do you want me to dial it again? Well, that's the communications. Yeah, they'll put you over to where he is. Okay, I'll dial it again, Louise. What? I said I'll dial it myself. I'll transfer you. Hold on. Oh, you can wait, don't you want to hear a joke? Yeah. The joke is IBM and Goodyear are going to merge so that they can manufacture a computer that makes snap decisions. Bye. That's a funny one. Hold on, Glendora. Okay, thanks. You're welcome.
a new one coming today. All right. And here is today's joke. That happened around 1:30 or so on Monday, November 1st, 1993. Today is November 2nd, 1993. Election day is 7:40 a.m. We're going to go vote. So we exercise our franchise at 7:56 a.m. and I'm going to start the 27A calls. A young man named Russell Brower had an ad in the Penny Saver. So we called him and left a message on his recorder. Did he want to buy an ad on television for $500, including the videotaping of the commercial on the big time, channel 247, and 100,000 viewers. He called back and he wanted to do it. And he gave an order to do it, and we made the arrangements to videotape it and to write the script and for me to pick up the $500 on September the 28th, 1993, Tuesday. And I said, are you going to pay by check or are you going to pay by cash? And he says, I'm going to pay by cash. And so it was left that we would meet. I called WNBC TV, Channel 4. They had the best deal at the moment. And I ordered the spot, 1 30-second spot, to be on October the 30th, or 29th, October the 29th, Thursday night. It was on a replay of the 11 p.m. news. The 11 p.m. news is very expensive. It's about $4,000 per 30-second commercial. But they dump these commercials all out, and then they replay the news, the 11 p.m. news at 2 a.m., and that's how come I could get him that price. I received a confirmation from WNBC TV for the order, and then I called him up to tell him that he was confirmed, that he was in, and we were all set for the date that we planned on, October 29th. And then on September 27th or 8th, we were going to videotape the commercial, and we were going to write the script, and he was going to give us the $500. Well, he began to renege. He began to go back on his word. And he made the excuse that he hadn't talked to his partner about it. Well, it's too late for that. He had made the contract. And he says, but I didn't sign anything. And I pointed out to him that in New York State, an oral, A-U or O-R-A-L, contract is as valid as a written contract. Well, sort of a fight ensued, and we kept calling him and telling him, this is all on audio tape, we kept calling him and telling him that we would be there, that we would keep our end of the contract, we would be there on September the 28th, Tuesday, at 16 Main Street in Port Chester, that we would be there. He has a music studio, and he had made arrangements to have the band play, his band. He has a band apparently, and that they would play during the commercial. This is a voiceover commercial. The announcer does the voiceover. We go and shoot the scene, and then we edited it, and then we put down the character generator, the graphics, and we get it ready on 3/4 inch, have it bumped up to 1 inch, which is the only format that the big stations will accept. And then they get it cleared. If they have any changes to make, we have to make the changes, consult the client, and negotiate that until we have something that both the client and the TV station will accept. All right, so he breached the contract. I told him he breached the contract, and I told him that he really couldn't do that. And so it came down to a claim in small claims court, a lawsuit in small claims court. Now this time I went to the Yonkers small claims court. You can do that if you live in Westchester. You can go to any of the city courts. You don't have to go where where the defendant lives. You don't have to go where the plaintiff lives. As long as it's in Westchester, you can go to any city court. And I chose Yonkers because Yonkers is so fast. When you file your application, they give you they serve the summons, and then they have the trial within a month. So that's where that stands with Russell Brower, Glendora versus Russell Brower. So far he's been a fugitive of service. The Yonkers City Court sent him the summons to appear in small claims court, but it came back at 16 Main Street. So now we're trying another address, which is something 32, something, I don't know where it is. It's in Hartsdale. I'd have to look it up. Well, all right. Now, similarly, the Martial Arts Institute of America, which is on Court Street right next to Woolworths in White Plains, did the same thing. They made a contract. It was for $500. And if you don't change the commercial in any way, right now the price is you can come back for $200, and the repeats are $200 if you don't change the commercial. It's a marvelous deal. In 42 years of television, I have never seen such a low price. And this is on a major, major TV station. So Master Park made the contract with me, and we had it all set up for me to go there and videotape. This was in May, I believe, 1993. And then I called up to say that I'd be there the day after tomorrow. And he says, I was going to call you. And he didn't want to do it. And I said, what is your reason? And he says, I need Mr. Bell more than I need you. Well, Mr. Bell was an intruder, and you can't work with an intruder. You have to work with the person with whom you make the contract. And I'll read to you in the contract law why that is so. So I brought an action against him in the small claims court in White Plains, breach of contract. And there in White Plains, it's impossible in White Plains. You know, they should do way better than this. They couldn't have a trial until October. Isn't that outrageous? Okay, so we went to the trial in October. It was October the 27th, Wednesday night. Judge Joanne Freya was presiding. And she has, the first time on, you don't have a trial. You have to wait another month for a trial. It's ridiculous. Small claims is supposed to be a speedy resolution to a dispute. Well, that's not speedy. 7 months. And so that's why I'm not going to file any more small claims actions in White Plains City Court, because that's ridiculous to have such a long delay. One action I had in White Plains City Court took a year and 2 weeks, and that was small claims. Okay, so we went there, and Master Park was there in his karate suit, and Mr. Bell, who is really an intruder. He's nothing but a student there. He has no official capacity at all. And so we were called, and Judge Freya asked if we would accept an arbitrator. And I said no, because I may want to appeal the decision. If you have an arbitrator decide it, you cannot appeal that decision. Remember that. Only if a judge decides it can you have an appeal. And so then Judge Freya says, well, will you go to an arbitrator and see if the arbitrator can help you settle this matter out of court? So I agreed to that. It was a wrong thing to do. It was I'll never do it again. The arbitrator was Mr. Levine, a lawyer from Mount Vernon, and Mr. Bell intruded and over-talked and above-talked everybody else. I had my audio tape where Master Park made the contract with me and where he breached the contract with me. And it's a 30-minute audio tape. So that just was a whole lot of hollering and a big fight, and it really amounted to nothing except that. This was wrong too. Master Park got a delay when we came back into the courtroom. A trial was going on, and Master Park wanted to ask the judge if he could have a copy of my audio tape. And so I wanted to go, but Trudy, the clerk, says, no, there's a motion. Well, there couldn't be a motion. There was no court. So I waited for this trial to be over. It was a very sad trial about a woman who put down $1,000 to a real estate company to pay for an apartment, start paying for an apartment. And she didn't have any documentation, and she didn't have any proof. And the real estate company had all the letters and all the proof, and they even had a lawyer. So it's too bad she lost. It was very sad to see. But you have to give Judge Joanne Freya a lot of credit. She really conducted that trial well. She really tried to give this pro se tenant the benefit of whatever she had. And naturally she had to rule, she said, in favor of the West, what's it called, West Corp. It's over in Hartsdale, Realty Corporation. So I had to wait until that, and it wasn't until 9:20. And this is outrageous. I got there at 7. Here it is 2.5 hours later. And Judge Freer called us forward, and she asked me, they said they wanted a copy of the tape, and Judge Freer asked me if I'd give him a copy of the tape, and I said, no, Your Honor. And Judge Freer said, how long is the tape? And I said, 30 minutes. And she says, what's on the tape? And I said, what's on the tape is that I made these people an offer. They accepted the offer. I made Master Park an offer. He accepted the offer, and he breached it. And I want my damages. That's the whole essence of the contract law. And so she said, well, how long is the tape? And I said, 30 minutes. And she said, well, will you go inside and let them listen to it for 30 minutes? No, no. And so Judge Freer said, well, she said to the defendant, Master Park, Mr. Bell, she says, all right, then we'll have to hear the tape, if I hear it at all, if I accept it into evidence. Well, boy, she'd better. If I hear it, when I hear it, you'll have to hear it just as I hear it for the first time. So we left there about 9:30. Oh, and I didn't tell you, when we walked into small claims court at 7 p.m., there were 2 video cameras, big TV station video cameras, big broadcast TV station cameras, not cable, broadcast. It was Channel 7, and guess who the reporter was? Diana Williams, and guess what the story was? A landlord-tenant dispute. Wrong. Take that back. It was not landlord-tenant. It was 2 property owners disputing over the same piece of land. And Judge Freer called them forward, and it was really out of sequence, how she usually calls things forward. And Judge Freer did all of the talking, and she urged these people to get together and settle this. And she says, for the moment, I'm going to dismiss the case. I guess she didn't dismiss it on its merits. I think she dismissed it on a technicality that the case should not have been in small claims court. It should have been in property law court or whatever court. It shouldn't have been in the White Plains small claims court. So that was pretty interesting. We all had to wait while Channel 7 took down the cameras and took down the microphones. I thought, and so did Franklin think, and I think another lawyer I was talking to, that it was sort of staged, especially for Channel 7. It wasn't real court, but we'll see. We'll see. And this piece that Diana Williams is doing is 2.5 minutes long. And you know how long she's been working on it. Okay, now I'm going to just read you the contract law. Just points to the contract law. So for 2 reasons. One, that you know that when you do these things, you are making a contract and you are liable. And 2, if you do this to anybody, that you know that they have made a contract and they are liable to you. The first thing in a contract is an offer is made. Okay, I made the offer to Brower. I made the offer to Master Park Martial Arts Institute. A contract is an agreement in which a party undertakes to do a particular thing. Bilateral promises, promises on two sides, in mind that a contract is a transaction in which each reciprocally acquires a right to what is promised by the other. Defined as a verb, contract means drawing together of the minds until they meet. The word agreement connotes a mutual obligation. You and I have a mutual obligation toward each other, Katie Cat. I will feed you all day long. And what will you do for me? Nothing. A contract creates property rights which may not be taken away from a party thereto unless by his consent or by default or failure to comply with the terms thereof. Easy, isn't it? Now this is from New York jurisprudence. Express contracts consist of these agreements in which the terms are stated by the parties. The parties arrive at their agreement by words, whether oral or written. An oral contract is just as valid as a written contract. And both of these were express contracts. It was expressed what I would do for them, videotape, write the script, have the videotape edited into a 30-second commercial, have it bumped up to 1 inch, submit it to the TV station, buy the airtime, get the time, and notify the client of the minute, the hour and minute that he was scheduled to be on the air. Their part of the contract was to pay $500. So that's an express contract. Now, the question of whether a binding contract exists is basically one of the intent of the parties. This means that the manifestation of a party's intention, rather than the actual or real intention, is ordinarily controlling. That means he manifested an intent to do this. Whether he intended to do it or not doesn't matter, but he manifested that intent. This is what you call a meeting of the minds. The minds of the parties must meet with respect to the nature and extent of the obligation assumed and as to all the material terms of the contract. Parties must deal fairly and in good faith with each other. I certainly dealt in good faith. Brower, I question, and Martial Arts Institute of America, I question. An offer is essential to a contract. It may be made by words or acts. An offer must be communicated to the proposed acceptor and accepted by him before there is a contract. So you see, I made the offer and it was accepted. That made the contract. In order to constitute a contract, there must be an accordance, an acceptance of the offer. Until the offer is accepted, both parties have not assented, or in the figurative language frequently used by the courts, their minds have not met. Well, I made the offer, they accepted it, our minds had met. See, these are just a few simple points for you to remember. The completion of a contract may be made by telephone. When the acceptance by telephone is spoken, the contract is consummated. I bet you didn't know that. That's the first thing Brower says. I haven't signed anything. No, that's not what the law goes. Consideration for a contract need not be recited or expressed in writing. In other words, an oral contract is just as valid and viable as a written contract. Presumptions, pleading, and burden of proof. The law contains a presumption in favor of the legality of contracts. What kind of a society would we have if it didn't? The law contains a presumption in favor of the legality of contracts. Absolute renunciation of a contract by one of the parties thereto constitutes a breach thereof, for which he is liable in damages. The refusal of a party to recognize the existence of a contract, or the doing of something inconsistent with its existence, may be treated as a breach thereof. Performance in the true spirit and meaning of the agreement is expected in the law. A person is bound to do what he agrees to do, whether or not he intends to do what he agrees to do. Whether or not he intends to do what he agrees to do. He is bound and expected to do what he agreed to do by the law. A person is bound to do what he agrees to do, whether or not he intends to do what he agrees to do. Natural justice and the stability of society require the courts to compel the performance of contracts as they are written or spoken. Although there is authority to the effect that a party to a contract founded on concurrent conditions must show merely he was ready and willing to perform his part of the agreement, what that's saying is that I, the plaintiff, have to show that I was ready, willing, and able to perform this contract. I was ready, willing, and able to perform this contract. Concurrent promises means readiness and willingness accompanied with an ability on the part of one of the parties to do the acts which the agreement requires him to perform. I certainly was. I still am. Provided that the other party will concurrently do the things which he is required by the contract to do, and notice by the former to the latter of such readiness. They agreed to that. So, again, the plaintiff has a legal duty to perform the act promise. The implied obligation in a contract calls for fulfillment of the contract without searching for excuses for performance, however plausible it be. Was that he wanted Mr. Bell to handle the was a change in the agreement. He wanted him to handle the arrangements. Impossibility of performance does not ordinarily relieve a contracting party from liability. Let me read that again. Impossibility of sense of frustration, cut. A breach is effected and the right of action is completed he agreed to perform. In the case of who tried to bring in the complaint in an action to the existing and there myself, plaintiff, the option to the state of New York, and it will say to Grandmaster Kim, greeting. We command you that all business and excuses being laid aside, you appear and attend before the small claims court, city court of the city of White Plains, on the first day of December 1993 at 3:30 o'clock in the afternoon, at any recess or adjourned date to give testimony in this action. Failure to comply with this subpoena is punishable as a contempt of court and shall make you liable to the person on whose behalf this subpoena was issued for a penalty not to exceed $50 and all damages sustained by reason of your failure to comply. Witness, Honorable Joanne Freer, one of the judges of the said court. And this was signed on Friday, November the 5th. Here's the little piece of paper that cost $1.50. It doesn't cost, though, the White Plains City Court did not charge to have the subpoena made out. Then you, after you get the subpoena, they don't serve it for you. The court does not serve it for you. And you have to go out and have it served. Rules of service are very easy. The person who serves it can't be any party to the action who serves it. Be over 18 years. And you have to not be a party of the action and be over 18 years old. Gregory said that his doctor said that jogging could add years to his life, and Gregory says it did. Right now I feel 13 years older. Annette, she says she has the body of a 20-year-old, and her mother-in-law said, give it back, you're getting it wrinkled. This is Glendora, a chat with Glendora. I hope that we've helped you stand up for your rights and know what the law is, where the law protects you, and that you don't get ripped off. Keep the courage flaming. Hi there, everybody. How you doing today? The temperature is 60 degrees, and it's sunny and balmy, and here it is, the 14th of November, about a week and a half before Thanksgiving. This is mailing number 108 of November the 9th, 1993 week. What happened, Glendora versus Scott Lord, Jeffrey Barnes, and Jan Stahl. From records, Glendora went to the Office of Consumer Affairs in Nassau County to see the licensing guru, the chief investigator, and the Freedom of Information officer and the files. She got copies of the letter telling tri-state license would be suspended unless judgment against them was resolved, and of Stutch Stahl, S-T-H-L, to challenge it in district court. She showed the videotape of the Scott Lord Group, the Atlantis Lawn Sprinkler Group, a new name every year, and the evidence of Scott Lord operating without an Office of Consumer Affairs license. From there, she went to the bankruptcy court, and there is nothing new in the file. The bankruptcy court now has a third judge, Judge Ryan. The marshal says there must have been 200 people there today, and Glendora said, sure, it is a ripoff. It is a quick fix. It is one bankruptcy lawyer after another getting $1,000 and one crook after another ripping the honest people of society off and getting away with it. Glendora told the marshal about her 67 cents on the dollar and about getting paid $3,100 April 1st, 1994. If she releases the trustee from all lawsuits, from the beginning of time to the end of time. The marshal said to get the money first, then release him. Right. 4:45 p.m., Glendora headed for Westchester. The arrival time was 7:10 p.m., and Glendora spent 15 hours chasing this crook Scott Lord. It was $15 for gas, $13 for tolls, and $13 for copying. It was $0 for meals because Glendora fasted all day. There was mention of Scott's being associated. Cut. The joke of the day, Carolyn brags she has the body of a 20-year-old, and her mother-in-law says, give it back, you're getting it wrinkled. November the 8th, 1993, Monday, on Glendora versus Scott Lord, etc. It took twice as long as planned to videotape for TV what happened on the Scott Lord matter last week. The editing of this will be done in Nassau County. It will be Chapter 19 and Chapter 20, maybe Chapter 21. Glendora cannot get in touch with the trustee O'Connell. The United States Office of Trustees, Executive Office, Washington, D.C., called Glendora yesterday. That is Martha Davis. She had Miss DiCamillo call. They have done what they are going to do on the administrative claim, have turned it over to the civil division, and what this means nobody knows, and only several more telephone calls will find out. O'Connell's notice of entry came of Fredman's bad decision. All over New York State today or tomorrow, people will be reading about this bad decision. Protests went out yesterday to 12, including Cuomo, Judge Kaye, and Judge Trafficante. Time on Scott Monday is 1/2 hour. Add to this the extra hour to videotape yesterday, Tuesday. November the 9th, 1993, 4:30 a.m. Glendora made 3 copies of the summons with notice and complaint to serve again, and this time personally on Lord, Barnes, and Stahl. They are fugitives of service. Let me show those to you. Those are the affidavits of the service. Okay, here are the summons. You've seen the summons before. This is the same summons that went out on March the 30th, 1993. But being fugitives of service, they demanded personal service, so that's what they're going to get. So these are going to be served on them personally. And here is what the affidavits look like. And so, listen, if you're going to serve anybody personally, it's very, very easy. Don't go out and pay a process server $40 or $50 to do this for you. You get somebody to do it. Your mother can do it, your father can do it, your brother can do it, anybody can do it, friend can do it, as long as they're over 18 years of age and as long as they're not a party to the action. So don't be suckered into paying $40 for service. You go out and have it done yourself and do it with somebody. You can't do it, of course, if you're the party to the action. Okay, now where were we? So Glendora is going to have these served personally on those 3 people to see if the court will get down to its job and deal with the issue, which is negligences. Then the affidavits of service, blank forms, were made ready. Glendora log filing what happened and packed for the trip to Nassau County. The time is 6:21 a.m. Paginate. Head for the Hutch, I-95, the Fox Neck Bridge, Grand Central, Northern State, Willis Avenue, Hempstead, and piles of offices. The back of 13 Center Street is all cleared out of all Atlantis trucks and trappings, except for a roll of underground tubing for sprinklers. It looks good for the first time, instead of like the South Bronx. In the front of 13 Center was a truck that said, quote, Lawn Sprinkler Group, wells, pumps, etc., attached to the rear of the truck. a van, and there was a compressor to it. Glendora videotaped it. Glendora videotaped the sign on the door of the Scott Lord Group and the sign on the wall, Aquamis Atlantis, Forever Green, Wells Pumps, Lawn Sprinkler Group, etc. And two men were sitting on the parking ramp wall across from the street, the parking ramp for the district court. Now I'm going to show you a videotape of what I saw there, so you can see it for yourself. Glendora asked these two men about Scott Lord. One man said he used to work for Tri-State. He worked for them for 3 years. He gave Glendora a lot of information. He lives near the area. He is upset that Scott fried him. He's disgruntled. And he asked Glendora to pay him for the information. And he was without a job. Well, Glendora said that she wouldn't pay him for the information because she wasn't sure what the law is, if you can pay money for information. But as she would to anybody who was down and out, she gave him money. I gave him $5. It was a donation. And around 8 a.m., Scott Lord came out and drove away in that truck that you saw. Another man named Peake got into the passenger side. The thing to do some other time is to follow the truck and see where Scott Lord goes and what he does and show Consumer Affairs that he is operating a business without a Consumer Affairs license so that they can turn him over to the district attorney and so that there can be a warrant put out for his arrest. It is amazing that this is happening again, just as it has happened for years. Do you remember Scott Lord telling Glendora in the summer of 1992 he wanted his own business back? And Office of Consumer Affairs said talk to Glendora to get rid of the judgment, and that Scott wanted to settle with Glendora and pay her $4,600 in installments. That is forever green, forever default. Scott reneged on this too, you remember that? So now he has his own business, but as ever, illegally, without a license from Consumer Affairs. And he's operating out of the building that was formerly owned by his father, Marvin Lord. Glendora drove off, circled the block, and came back to the parking ramp. She talked to that man again who used to work for Scott Lord about serving on Scott Lord personally her summons with notice and complaint. So they made arrangements to do it the next morning, which was Wednesday. Now, about paying for information, my lawyer tells me that you can. You can pay for information. I don't like the idea, so I guess I won't do it. Glendora went to the district court, the civil clerk, to look up law papers involving Tri-State. She found the old Slomans that has been resolved. She found Tri-State against Grossman Nursery for breach of contract. She copied the papers that showed Scott Lord made the deal with Grossman. She found it, and that's to show Consumer Affairs because that's in violation of the stipulation that Jan Stahl and Jeffrey Barnes signed with Consumer Affairs, that Scott Lord would never act as a manager inside or outside of Tri-State. And when Glendora reads what she copied, she will tell you about that one. Before she can read these, she has to group them and put them in order and staple and paginate them and find the time. Then it was a rush to get to Supreme Court to observe the appellate term. There were 3 judges. There was Judge Luciano, the new one from Suffolk. There was Judge Stark, another judge from Suffolk. And our friend, the one we like the best, Judge Papalo, was not there. He's the presiding justice. But Angelo Ingrassia was there. Glendora's Westchester judge was there. She exchanged greetings with the clerk she knows and the court officer, and when the oral arguments were all heard, the judges had the 2 big tables moved together, took off their robes, and sat down in their shirt sleeves to make their decisions. Glendora left, went to see a couple of Supreme Court clerks she knows, and then went to see the deed on 13 Center Street. She had to get the section, block, and lot number. Then she found the deed and copied it. Peter Alexis bought the building from Jeffrey Barnes. Glendora has the deed when Barnes bought it. It was about January 1992. The building originally belonged to Scott Lord's father, Marvin Lord, who lost it through financial failure. Marvin Lord died in Great Neck in 1988. Glendora read it all in Surrogate's court. It's a very, very sad record. Also that Marvin Lord refused to leave any money to Scott or to his 3 other brothers, but left all of his money to his son Dean. That's the only money that he would left to any son was to Dean. Glendora has wondered for years if the Lillian in that surrogates paper that she saw, the Lillian who works at Tri-State and has for years, was Scott Lord's mother. And come to find out, it is. Lillian Rosenblum or Rosenthal is Scott Lord's mother. Glendora searched the business names file and the corporation file to see if lawn sprinkler groups Forever Green Atlantis were registered. They were not. The old Atlantis Lawn Sprinkler Incorporated that Glendora sued and that went bankrupt and has been and will be dissolved on April the 1st, 1993, was there, and also Tri-State. There are Forever Greens in great multiplicity. One of them has a 1993 judgment against it. The next stop was the county clerk's office. When Glendora asked the clerk to bring up the name Atlantis Lawn Sprinkler on the computer, there was a whole page of judgments. Glendora went to records and got copies of Forever Green business certificate owned by somebody named Sferaza in Wantagh of March of 1993 in the state's warrants against Tri-State. 5 a.m., dressed up, put some order into the copies of yesterday, entered the expenses into the finance book, paid Con Edison, and packed up again, left at 6:10 a.m. for the Hutch Y95 Clearview Fogs Neck Bridge. 695 Grand Central Parkway, Northern State, Willis Avenue, Franklin Street, and Hempstead. And when I go through the Fogs Neck Bridge, I always leave my card to give to John Ryder and to John Hickey. They are friends of mine, and John Hickey is a manager of the bridge, and John Ryder works for them. There was at 7:04 a.m. no truck nor activity in the back of 13 Center Street. Yesterday, before Glendora left Hempstead, she went into the office of the Scott Lord Group and asked if they had seen her on TV. Barbara was on the phone, and Sherry said belligerently, "Why should we?" And Glendora said, "Oh." And Sherry said again, bellicosely, "Why should we?" And Glendora said, "Okay," and left. There was no Scott Lord truck outside 13 Center Street this morning, Wednesday, in the metered street parking place as yesterday. Glendora videotaped the front of the building again and showed its contiguous position to the district court. 7 to 7:30 a.m., no Scott Lord showed. You want to know why? He got wind that I was there and that I was going to be there again today. Two street people were kicking and shoving each other in the middle of the block toward the district court. 7:30 a.m., Barbara showed up in a Mark 7, and she unlocked the grate, and opened the door and turned on the lights. And at 7:30 a.m., the man who used to work for Scott Lord came and said no, he would not serve the papers on Scott Lord. He was afraid of retaliation. He was afraid that something would happen to his children. So he has the $5 as a gift of a donation. Now Peter Alexis was there. Glendora asked Peter Alexis if he wanted to serve Scott personally, and Peter said he could not. He's my tenant. Does that show you, Mr. Sweet, that Scott Lord is operating a business without a consumer affairs license? The man working for Alexis is Carlos. Glendora complimented Alexis upon how he had improved the looks of the building. The new roof that Glendora saw was being installed last summer, the painting of the building outside, and the painting of the office inside at door number 17. Where Tri-State was, as you saw, is locked up and empty. Nobody is there. Tri-State fled in the middle of the night. Peter Alexis says a little bit at a time. Glendora tried the Nubia Cafe across the street to see if anybody there wanted to do the service, and it was locked. The next thing to do was to go to district court. Since there, Glendora stood in line at 8:30 a.m. A line forms all the way down Center Street. The heavy security checks slow up everything. What has happened to poor society? Glendora went to the civil clerk and looked up a new case against Scott Lord, Ariella Lord, and Lillian Rosenthal from Royal Indemnity Company for about $220. Glendora knows what they are going through trying to collect from Scott Lord. She also saw the case where Scott and Ariella did not pay their bankruptcy lawyer, M.S. Eisenberg, for her work on the 1985 Chapter 13 bankruptcy. Now that's funny, because Eisenberg is now a bankruptcy judge. She's a judge alongside Judge Hall in the Eastern District, Westbury, in the bankruptcy court. And this is the lawyer that Scott Lord and Ariella Lord did not pay. However, the paper, as far as I could understand it, said that it was all right, ruled that it was all right, and it looks like Scott Lord and Ariella won that case. Glendora stopped at business records. There were no lawn sprinkler groups incorporated listed. This is going from Hempstead to Mineola to the Supreme Court to look for a process server. And then the next stop was the county clerk, and she asked the clerk to punch up Scott Lord, and the county clerk reeled backwards because up came a whole page of judgments against Scott Lord. She hits another button, up comes page 2, nothing but judgments against Scott Lord. She hits the third button, up comes another page, whole page, judgments against Scott Lord except for 2 entries for somebody else. Glendora looked at the record between Jan Stahl, which is a case he brought against Blake Denham, and he won that. And a process server said that it would cost between $25 and $50 to serve each one of these people. And so Glendora said, no, she will go home, come back, and have her husband serve him. My husband's a very good, he serves paper very well. Let me tell you how that has to be done very quickly. You walk up to the person, you ask them their name, you ask them if they are so-and-so, the person. So, are you Scott Lord? And whether they say yes or not, you say you are served. You know that it is Scott Lord. And of course there will be violence. You know, they'll brush the paper aside, they'll kick it aside, they'll drop it on the floor, they'll do anything, maybe. But what happens to that paper after you? The words are, after you have delivered and left it. Delivered and left. That's all you have to do. Just deliver it and leave it. And what happens to it after that, you don't have to worry about. The person has been personally served. Well, now, at 12:30 p.m., Glendora headed for Westchester and arrived at 1:30 p.m. She fasted all day again. That's 2 days in a row. She telephoned 220 calls, and after that sorted out the Scott copies into groups and put the groups into order. That was another hour, and the time on Scott today was 10.5 hours. The cost was $6.50 for toll. Copying cost is figured into yesterday's at $13. Add another $2. Glendora got the quarters from the Hutch toll booth as she passed through. $10 roll Tuesday and a $2 worth today. When Glendora pays her $6 on the Fogg's Neck Bridge, as I told you, she gives her card for John Hickey and John Ryder. We were negotiating to do a feature on a chat with Glendora on the Fogg's Neck Bridge. Joke, Daddy, what is an example of minority rule? Daddy, having a baby in the house. November the 10th, 1993, Wednesday. 2:30 a.m. Glendora paginated the research gathered yesterday and the day before. The file is up to a grotesque 4,582 pages, all on Scott Lord, because Scott Lord could not deal honestly and honorably and still goes on with the same pattern, now operating a business without an Office of Consumer Affairs license, home improvement. Time on Scott Lord today so far is 3 hours. It is after 5 a.m. and time to start the party in reward for fasting 2 days in a row. I was down to 140 pounds. Glendora has fasted 6 other days this month. Now, jobs to do on Scott are personal service on Scott, Barnes and Stalls, settle with O'Connell about the release and the $3,100, keep after the administrative claims, get out the mailing number 107, printed, reduced, printed, folded, stuffed, sealed, posted, another $50, envelopes addressed, and videotape all this for TV and edit it, and take it to Nassau County for televising. November the 11th, 1993, Thursday, Veterans Day. Frank was a veteran. He was in D-Day, and he was in the Army, the First Army, from 1940 to 1945. Thank you, Franklin, and thank you all the other veterans. Franklin spent an hour reducing the what happened log number 107 ready to paste up. We did the 38 envelopes we send this bad record to. Just as Glendora was leaving to edit at 3:50 p.m. to be at TCI, by 4 p.m. the telephone rang and Glendora heard Richard O'Connell leaving a message on the telephone answering machine. This was a tear. You know, editing is very important. Talking to Richard O'Connell is very important. So I picked up the phone and I told him that I had to go edit and I wanted to talk to him. It was very important. And lost editing time cannot be regained, folks. O'Connell said the lawyers in bankruptcy court tell him that they see and read about him every week on TV. Glendora said she would sign a release on April the 1st when she gets her $3,200. She will release him in this matter. That's what everybody else does. She still protested the release for all time on all things. Glendora has asked if she could call him tomorrow, and he said about 1:30 or 2 p.m. Glendora sped to TCI, but she did not edit the New Scott chapter, what happened the week of November the 1st. She will save all Scott editing for Nassau editing. Time on Scott today is 2 hours. The 12/1993 folks Friday, there was an appeal to perfect. There were affidavits of service to get notarized and filed with the county clerk. There was pile on pile to do. Glendora never got to telephoning and never got to call Richard O'Connell. That's bad, very, very bad. Glendora read the first group of material about Scott, Stahl, and Lord et al. Brought it back from Nassau County Tuesday. Scott and Ariella did not have to cut. Administrative claim called and said the matter has been given to some division, and Glendora would hear from them in writing. Nonsense. Where is Chastain? He took the day off. Did you have Veterans Day off yesterday? Yes. That is the way people are. You give them one holiday and they got to take 4. I think the Japanese are right about Americans being loafers. 6:57 p.m. Scott filed, 7:30 p.m. to sleep, 4:55 p.m. Cablevision called, 1.5 hours on Scott. Pete, before I got married, I had 3 theories on raising children. Now I am married, I have 3 children and no theories. November the 13th, 93 Saturday, 5:30 a.m., cut and paste up the reduced pages of the 107 mailing, make a master, added 2 names to send it to, Janet Reno and the United States Marshals. 2 hours on Scott up to 7:45 a.m., 8:30 a.m. do today's reading of the Nassau County Research on Stutch and Stahl, S-T-A-L-L, S-T-H-L, to keep Tri-State from having to pay that New York State judgment against them. Stutchen was devious not to send to the Office of Consumer Affairs a copy of upon the affidavit of Scott Lord. He should have sent that affidavit of Scott Lord. OCA should have had that, and Glendora should have had it from OCA. Such an affidavit shows further that Stahl and Barnes are violating the stipulation Patterson had them sign that Scott Lord would not act as a manager inside or outside of Tri-State. This is another blot on the escutcheon. 9:14 a.m. Done the reading for today. Picked out a lot of papers to include in this mailing for number 108. Number 108 is up to 24 pages already. The time of Scott Lord today is 3 3/4 hours. Joan and Bob stayed out too late, and they rushed home. And they said to the babysitter, "We apologize for being late." And the babysitter says, "That's all right. If I had kids like these, I'd stay out late too." November the 14th, 1993, Sunday, before church, the files are in order. Glendora read 3 groups of Nassau Research. She found a lot of things that have to be circulated. That will be mailing number 108, is already over 32 pages. The time in Scott this week is 41.5 hours. Yet to do is copy the log, 107, full stuff CO post. And the cost is $20 postage and $40 printing. Glendora also has to videotape what happened this week. That's 2 hours, and this is for TV. And 5-year-old Henry, watching the escalator, said, "What happens when the basement fills all up with steps?" Need of 13 Center Street, 17 Center Street, the building going from Jeffrey Barnes to Peter Alexis. Now, to see how much money was exchanged for this, we will have to get the mortgage. But we certainly got the section block and lot number. It took a little time to get that. Here is a deal signed by Scott Lord for Tri-State on the matter of Tri-State versus Grossman Nursery. That was a lawsuit that Tri-State brought against Grossman, breach of contract, but it seems that the court has, what did he say? Anyway, it's not in the court any longer. It's out of the court. I have what the judge said on that. Okay, so I'm sent that to Bert Patterson this morning, my comments about that. You know, what is Consumer Affairs doing about Scott Lord with all of these judgments against him? And he's lost so many people money, and here he is out operating again, and he isn't cleared through Consumer Affairs. And I also asked him, what is Consumer Affairs doing about Tri-State pulling out in the middle of the night, disappearing entirely, and who's got their license now? So those are the two things that I think Consumer Affairs should do. After all, the raison d'etre for Consumer Affairs is to protect consumers from fraudulent operators. And it looks like we have 3 of them here. And they've failed badly in the past year on this. And I told that to Consumer Affairs, and I found that Mrs. Kemp and Mrs. McDonald were belligerent, were arrogant, and were rude, and were unreasonable. And they constantly intruded when I was talking to Bert Patterson and to Mr. Sweet, and when I was trying to show them that videotape. I think that's uncalled for. I don't think Mr. Glendora is that way himself, and I don't think that he would like that. And when I get time, I guess I've got to tell Mr. Glendora that. Okay. So, remember we asked the clerk to pull up the record on Scott Lord. There it is, the top page, whole computer page. Bottom page, whole computer page, all Scott Lord. And the third page is all Scott Lord except for the last 2 names. These are the judgments against Scott Lord in the Nassau County Clerk's Office. Here are the judgments against some Forever Greens. There are several companies, Forever Green. And now Scott Lord is using the name Forever Green. He's been fooling around with that for 2 or 3 years. And here's a judgment, I don't know, something about Jan Stahl, but I guess it's satisfied. Yes, it's satisfied. Okay, that's good. Mr. Sweet, Consumer Affairs, Lillian Rosenblum. Mr. Sweet keeps calling Mrs. Rosenblum Mrs. Rosenthal, but it's Rosenblum. And she writes him this note: Mr. Sweet, arrangements were made to pay the lien from the Department of Labor. A license renewal was refused because when asked if there were any pending liens, the answer was yes. As you can see, we are meeting our obligations. Yours truly, Lillian Rosenblum. Please advise, and she's Scott Lord's mother. And here's some kind of a record of payments, that they couldn't meet their payments. And here is a check, Tri-State Irrigation, signed by Scott Lord's mother, Lillian Rosenblum. And here is Barbara Hunt. See, this is what's so bad about that. She signs this agreement, and she's just an office worker, and she's not there anymore. And she only was there. She was there less than a year. New people come in every year. Every year, there's new people. And here's a copy of the judgment, transcript of the judgment against Tri-State Irrigation. And here's a letter from Consumer Affairs to Tri-State Irrigation. Dear Sir, our office has been advised that a judgment has been rendered against you in favor of Commissioners of State Insurance Fund. As a licensed home improvement contractor in Nassau County, it is mandatory that you meet your financial responsibilities. Your failure to satisfy this judgment within 5 days may result in this office suspending and or revoking your license. Very truly yours, James E. Picken, Commissioner. Signed by Bertram F. Patterson, Assistant to the Commissioner. Date of that is August the 20th, 1993. Now, here's the judgment that Glendora got against Scott Lord through the bankruptcy court. The one that I should get my money for on April the 1st, April Fool's Day. And this is the one that Richard O'Connell worked so hard to get and did such a very good job on. Now, they put down the full amount of this judgment, $54,887.48. You remember I told Judge Hall you can keep the 48 cents, and Judge Hall said, sit down. And here's the abstract of the judgment. It says $35,000 original judgment on third claim, plus the interest of 9% per annum from March 3rd, 1989. That's when the fraudulent conveyances were committed between Scott Lord, Jan Stahl, and Jeffrey Barnes. $10,500 is the interest. The original judgment on the fourth claim, $7,221.14 plus interest, 9% annum from March the 3rd, 1989, $2,166.34, a total of $54,887.48. I certify that the foregoing is a correct abstract of the judgment dated Westbury, New York, November the 12th, 1992. That's just exactly a year ago. This is November the 14th, 1993. Joseph P. Hurley, clerk of the court, and he's a nice man. A true copy attest. This is the action taken against Scott Lord, Ariella Lord, Lillian Rosenblum by Royal Indemnity Company. And the amount being asked for is $220. This is the case I told you when Judge Eisenberg was Scott Lord's lawyer in the 1985 personal bankruptcy, Chapter 13. Certified mail refused. That's why Scott Lord has to be served personally, where he can't refuse. Judge Eisenberg was with Bill Scott and Ariella Lord for something like $7,000 and 6.45 hours, $175 an hour. That's greedy. That would be a senior partner, a senior associate, 2.8 hours at $125, associate court time. Anyway, these lawyers never got paid. The court ruled that Scott Lord and Ariella Lord did not have to pay these lawyers. This is a list of process servers in Nassau County. I got that from the Nassau County Supreme Court Library in the Supreme Court building on Supreme Court Drive in Mineola. And my, what a fancy library. That is a big library. It's beautiful, and it's so well staffed. I must say, it's a lot more imposing than our Westchester County Supreme Court Library on the 9th floor of the courthouse tower. We have a courthouse tower that has 19 floors, and the Supreme Court Library is on the 9th floor. It's a very nice library, and the people are very nice. But the one in Nassau County is really plush. Connell's a copy of Judge Fredman's bad decision in order with a written notice of entry. And then we got one from Stutchin, except that Stutchin's is really defective. He says that it's an entry of a decision, and you can't appeal a decision. It has to be in order. So I called his secretary and asked him to do it right. This is the case against Tri-State Irrigation, against Grossman. But that was, here it is, for the order, per the order of Judge Richard A. LaPera, dated September 1st, 1993. Now that's only about a month and a half ago. The court has stricken this matter from the calendar. So it's tough telling what happened there. Here's the business certificate of Forever Green Landscaping. And the owner of that is William Sferraza. All right, I'll spell it. S-F-F-F-E-R-R-A-Z-Z-A. And he's in Wantagh. So I think there'd be a great conflict there. You know, Scott Lord using the name Forever Green, his using the name Forever Green. This is the form you make out if you want to go into business for yourself and have a business certificate, doing business as or become a corporation. Here is the judgment against a Forever Green Landscaping North Green Sprinkler Incorporated. State warrants. Boy, these people in the lawn sprinkling business sure do get a lot of state warrants for not paying their unemployment insurance. This one's for $1,452. And here's the transcript of the judgment. And I believe that that does it. As for what happened on Glendora versus Scott Lord, Jan Stahl, Jeffrey Barnes, and others, the week of November the 2nd, the week of November the 8th, 1993, and here's today's joke. Bobby brought home a report card, and it was all A's. And his father says, well, I guess he must get his intelligence from me. And his mother says, that's right, because I still have mine. Take care, everybody, and keep the courage flaming. Don't let yourself be ripped off. Not only by businesses, but by courts, and by judges, and by lawyers. Take care. How you doing? This is what happened on Glendora versus Gannett Broder the week of November the 8th, 1993. Monday, there was no time to work on Broder today. There was too much telephoning to do, 280 telephone calls. Tuesday, Glendora was in Nassau County chasing the bankrupt. He has opened up a business under a different name and is operating without a consumer affairs license. Every year he changes the name of his business, like hundreds of fraudulent business operators. I asked the county clerk to look up any judgments against him and came up 3 full pages of judgments against him, Scott Lord. We attempted personal service of a summons on him. We got business certificates, and we went to the Office of Consumer Affairs. Hi from a child with Glendora, and that's the first time that's ever happened. We better check it out. November the 10th, 1993, Wednesday, there was no time for Broder because of going back to Nassau and doing the rounds again. The 7 green cards were returned, so Kalaji cannot cry this time they did not receive them and that they did not receive Form 18A. Let's get down to the issue now, antitrust, and fight this case on its merits. November the 11th, 1993, Thursday, the flag is flying. Thank you, veterans, for saving us. Franklin is a D-Day veteran. He was in the First Army from 1940 to 1945. 1/2 hour on Broder today. The people in Nassau County see Glendora on TV a lot. They walk along the street telling Glendora that. In White Plains, Glendora had a judge for the defendant sign a subpoena to appear. All excuses and business being laid aside. That's what we ought to do with these Gannett people and get them to face the music. That's what I should do with Curry, Watson, Sherwood, Gray, Harrison, all. And they were fugitives. They never showed up at the trial in Harrison. You remember that? We pasted up the green cards for the record. There was a 1/2 hour on Broder today, and Daddy says, what an example. A little boy said, Daddy, what is an example of minority rule? And Daddy says, having a baby in the house. GCI was selling for 50 7/8, up in half. When Glendora last checked, there is no story in the paper by Broder for over a week. Franklin used to write 3 stories a day. This is not fair, Broder, to the shareholders. 2.5 hours editing Broder today. Program number 1336, Broder chapter 52. What happened October 18th, 93 week, October 25th, 1993 week, and November the 1st, 1993 week. Cleaned it up, the graphics, the music, the edits, and made a VHS. 1337, Broder chapter 53, finished the log. About 10 minutes into this program, wait to clean it up, and VHS after it is all filled up with what comes next. November the 12th, 1993, Friday, no Broder, no telephoning. I do not know where GCI closed. I had to perfect an appeal for the appellate division. I had to do 7 affidavits of service. And when Bobby brought home a report card with all A's, his father said he must get his intelligence from me, and his mother says, yes, he must. I still have mine. I also had to perfect an appeal to the appellate term on Monday of this week. And we also had to serve a summons with no complaint on 7 people. So it was a litigious week. November the 14th, 1993, Sunday, before church, the attorney at the Department of Justice, the Antitrust Division, sent an acknowledgement that he had received the summons served over with the Form 18A. 3 hours on Broder this week, plus a 1/2 hour to bring the TV report on videotape up to date. Ed, before I got married, I had 3 theories on raising children. Now I am married, I have 3 children, and no theories. This is Glendora, a chat with Glendora. Keep your courage flaming. Hey there, everybody. Here's what happened on Glendora versus the DHCR and others. November the 8th, 1993, Monday. There was no time to do Coppola, the DHCR today. The DHCR in with a written notice of entry. You think they learned? Glendora had to do 280 phone calls today. November the 2nd, 1993, Tuesday. Glendora had to go to Nassau County to chase the bankrupt. It is good that Glendora is getting 67 cents on the dollar. She should get it around April 1st with the usual delay of courts. Of course, taking off the 2nd and the 11th of November always helps to move things along, doesn't it? November the 9th, 1993, Wednesday, back to National Clerk to put the name as whole page of judgments, then up came a second whole page of judgments, and then up came a third whole page of judgment except for the last two names. The trip to Nassau, along with 220 telephone calls, left no time to write the Coppola protest. November the 11th, 1993, Thursday, Glendora spent 2 hours on Coppola, DHCR today. It was Veterans Day. My husband was a veteran. He was in D-Day. He was in the First Army from 1940 to 1945. We thank you, all you veterans. Will appeal all three of Coppola's decisions. They are all bad. Glendora wrote a page and a half of protest of the William Street paper Coppola wrote, whatever it is. He doesn't give it a name. Mary, the mother of 3 toddlers, was given a playpen, and she wrote a letter, and she said, "Dear Diane, thank you for the playpen. It's my most treasured possession. Every afternoon I get into it, and the kids can't get near me." November the 12th, 1993, Friday, no time to work on Coppola, DHCR. There was an appeal to and one to perfect for the appellate term. And we had to have 7 affidavits of service type today because we also served a summons with notice and complaint on 7 people. And that had to be submitted to the county clerk. And there was no telephoning even. Now that's bad. November the 13th, 1993, Saturday, Glendora worked 10 minutes on the Coppola protest for yesterday and 10 for today. We were done at 10:45 a.m., 3/4 of an hour today, DHCR Coppola. And when Bobby brought home a report card with all A's on it, his father said he must get his intelligence from me. His mother said, yes, he must, because I still have mine. On November the 14th, 1993, Sunday, another page was written on the protest to Coppola's third bad decision. The time on DHCR today will be an hour when this is videotaped, and for the week, 3 3/4 hours. Richard, before I was married, I had 3 theories. Now I'm married, I have 3 children. So the protest, as far as written, this is probably it. Okay, this is going to Governor Mario Cuomo and Joseph Trafficante. He's the head judge of the New York State courts outside of New York City. And E. Leo Malonis is the chief administrative judge in New York City. Angelo Ingrassi is our chief administrative judge in Westchester, 9th and 10th. Gary Gasana is the grievance committee. This will mean nothing. Gerald Stern, commissioner, another nothing. And Chief Judge Judith Kay and Glendora's TV audience. That's you. You're a something. To all. Judge Coppola was given an order to sign. That was at his request. This is the hard, dilatory way to do the job. The order was submitted to him on August 25, 1993. It was more than 2 months before he signed the order. Glendora has provided his secretary, Jeanette, a self-addressed stamped envelope after paying $245 to get a lawsuit into Westchester Supreme Court. One wouldn't dream of the court paying 29 cents to send you a copy of the decision or the order. It looks great, doesn't it? But Jeanette, instead of sending Glendora a copy of the order, sent the envelope to the clerk's office. So you can look at the 3rd floor of the courthouse office for that. Glendora called Jeanette and told her what she'd done. Jeanette hung up on Glendora, as she had done several times in the past. This is all on audio tape. No lies can be told. And when Glendora called Jeanette on November the 1st, 1993, Monday, to ask Jeanette to amend her error and mail Glendora a copy of the decision, of the signed order rather, Jeanette was laughing. Here she had all of the for voting, election day, and she had to abandon the public further by taking off another day. Many times you ring the cupola chambers and there is no answer. It takes 10 minutes to vote. Why do they need a whole day off to vote? You want to know why they are behind? In the Supreme Court, absenteeism. And they are absent from work today, Veterans Day. There is no need for Japanese right, our right about Americans being lazy. Glendora makes it clear she is not going to put up with their arrogance and their bullying. And couple this with the 16-page what happened log relating exactly as it happened other Neanderthal acts on the part of Judge Copola's staff. In fact, every judge's staff in Westchester Supreme Court. This log, having been sent to and was received by said staff, and this log having been sent to 22 people, including the governor of the Empire State, and the reason for this paper you see on the next page of Judge Coppola. That was the paper that I read you. It is clearly revenge. It is clearly the work of Jeanette and Howard Leitner, law clerk. It is clearly a power play. And what is it? And can any of you tell me what it is? Is it a decision? Is it an order? What is it? Is it an invitation? Can anything like this be appealed? Don't you have an order? This is not an order, or at least it does not look like an order. It doesn't say that it's an order. It doesn't say it's a decision in an order. Glendora called Jeanette and asked her what it was, but Jeanette hung up without answering. Does Judge Ingrassi discuss Glendora's protests at the brown bag luncheon every Wednesday? Glendora saw Judge Ingrassi this Tuesday at the term in Mineola. He said hello, but he did not say anything else. Glendora did research on Abrams' crummy argument to Coppola for one whole week. It was very, very hard work. She must have worked on that paper 45 hours. She showed Judge Coppola abundantly that all of Abrams' citations were in Glendora's favor, that one of the pages was a replica of an assistant attorney general's argument of 10 years ago. That's how much effort Abrams